Yes. As you know that today I am taking second class on the landmark judgment, that is Vijaya Singh Chandwa Jadeja and another versus state of Gujarat and other. Everyone knows that this is landmark judgment on section 50 of NDPS Act, which was decided by the Constitutional Bench of Supreme Court on 29th October 2010. It means this case was decided near about just before 10 years. As you know that what is the method of study? You are students, you should first of all try to see previous year question paper, and after analyzing the previous year question, you should start your reading learning process like this. That's why I have already, my point is that in this particular case, in this case, I will also discuss section 50 of the NDPS Act. Today I will not discuss because I have already discussed in the previous class regarding the state of Punjab, Joseph, Prabha, Krishna, Vijaya Singh and Arif Khan like this. It means there are 7 cases which I have to discuss at the time of discussing the Vijay Singh Chandwa Jadeja case. As you know that some students say that sir, why you take so much times even after reading 2 or 3 days, sometimes you feel uncomfortable and you do not take a class. As you know that teaching is a process, and this process must be followed with inner consciousness. If your inner consciousness is good and your inner consciousness is allow, yes, you are ready to teach, at that time you should teach. If you have any doubts, it is better to avoid teaching rather than to confuse your students. That's why, as you know that at time of discussing the Vijaya Singh case, I discussed all the landmark judgment based on the section 15. You can see, you can watch here. I have also discussed Arif Khan versus state of Uttarakhand, which was decided on 27th April 2018. It means I have to discuss all the cases. Come to the question, what was the question in previous year, and after discussing the question paper, I will discuss. Question is that a police party was proceeding from Gokul to Bhajanpura. As you know that this area is in the Delhi, and it means this fact is related to the Delhi. On patrol duty in Jeep. On the way, they stopped T. They stopped T. For the example, we can take name of the any person. Here I am taking the name of T, that is the Tripurari. On the way, they stopped Tripurari, who was coming on foot carrying a plastic bag. Who was coming on foot carrying a plastic bag in his hand. The police party apprehended T, being suspicious of him. Immediately, immediately, the most important word here is that immediately the police officer searched T without saying anything. Without saying anything. This is the points on the basis of which you have to decide whether Tripurari will get benefit of section 50 or not. The most important point in this question paper is that immediately police officer searched T, that is Tripurari, without saying anything. What is the meaning of without saying anything? As you know that when I was teaching section 50 class 1, at that time I clearly told you that there are 2 parts of section 50. First part talks about 1 to 4 class, which were initial, which were from the very beginning classes, and later on clause 5 to 6 were inserted later on. Clause 1 talks about duty of the police officer to inform. What is the duty of police officer to inform? But what happened in this case? Police officer did not inform anything to Tripurari. It means it was clear-cut violation of Section 50, Clause 1. It is this problem is based on in the case of violation of Section 50, Clause 1 and recovered large quantity of opium from the bag. This is the secondary point, it's not much more important. They recovered large quantity of opium from the bag. Now, what is the important point? What was the argument of the appellant? Argument of the appellant in this case was that whatever search procedure was going on, that was going on contrary to Section 50 of the NDPS Act. This is the argument. Argument was Tripurari was arrested and put on trial where he took the defense of the non-compliance. He took the defense of non-compliance and he now at present time before the Supreme Court. Now, Tripurari took the defense of non-compliance of Section 50 of the NDPS Act. Non-compliance because according to the Clause 1, he must be informed. Once he informed, Clause 2 said that Tripurari had option. Tripurari had option. Option was that there were two options. According to the first option, he may allow police authority, yes, you can search. On the basis of second option, he can say that don't touch my body, please produce me before the nearest magistrate. That's why main argument of the Tripurari was that, Millards, in this particular case, there is a clear-cut violation of Section 50, Clause 1, and in case of violation 50, Clause 1, of course, there was further violation, that was the Clause 2 and Clause 3. It means total failure regarding compliance of Section 50 of the NDPS Act. Now, question is that whether Tripurari will get benefit of Section 50 and will be treated as a acquitted. He will be acquitted. Simple question was that क्या त्रिपुरारी को Section 50 का benefit मिलेगा? If he will get benefit of Section 50, he will be acquitted? Answer of both the question is positive. Yes, Tripurari will get benefit of Section 50, Section 50 Clause 1, and violation of Section 50 Clause 1 provides ground for acquittal of his. So that's why I have to discuss the problem. For the convenience of the students, I have write your question in very brief. How to write the question, how to write the answer in semester exam. As you know that it is not possible to summarize in 1 or 2 lines, but in the brief, how to start, you can start in the brief, you can say in the brief that in this problem, several provisions and cases are involved. Several provisions and cases are involved. Why I am saying that several provisions and cases are involved? Because question is not talking about the Vijay Singh case. Question is not talking about the state of Punjab versus Baldev Singh. Question was not talking about Arif, Sumit, Prabhal like this. No. Question is talking about the Section 50 of the Act. Question is talking about the Section 50 of the Act. So this is the main point. It means if the question is based on the Section 50, we should write all these cases. But as you know that in the semester exam, finally you are the students, you are not writing the chapter for the book or article for the book. At least that's why a teacher expects that you will discuss some basic provisions. For example, at least you have to discuss Section 50 of the NDPS Act, State of Punjab versus Baldev Singh case, Vijay Singh case, Arif Khan case. At least these are three minimum cases which must be discussed to solve this question. You may say that, sir, why you are much more emphasizing on the state of Punjab versus Baldev Singh case? As you know that I will discuss wait for some time. What is the basic section 50? I have already discussed how to discuss section 50. There is no need to repeat again and again. My point is that what is the similarity between Vijay Singh case and Baldev Singh case? Please let me know one similarity. Similarity is that both the cases were decided by constitutional bench of Supreme Court. This is first similarity. Second and most important similarity is that both the cases were decided on the basis of referred order. That is, on the basis of referred questions. Why I use the word referred order? As you know that in the legal procedure, nothing is going on with the oral. Suppose that we have the division bench. Suppose that two students are division bench. अब प्रॉब्लम क्या होता है कि अब हम लोग जो नए बच्चे आए हुए हैं उनको कभी फेस देखे ही नहीं, उनका कभी नाम याद ही नहीं आता है, तो जब भी एग्जाम्पल कोट करना होता है तब हम लोग पुराने बच्चों का ही कोट करते हैं। तो नए बच्चे कभी कभी अनकंफर्टेबल महसूस करते हैं, लेकिन हम लोगों के पास भी कोई ऑप्शन नहीं होता है, इसीलिए एग्जाम्पल हमेशा मतलब पिछले ईयर के बच्चों को ही रख करके देना पड़ जाता है. दैट इज द प्रॉब्लम, अदरवाइज नथिंग इज, because everyone is equal for me. So my point is that what was the second point? Second point was that referred order. The referred order point is that suppose that there are division bench. Suppose that in the division bench, Shivani and Talat both are in division bench. They have to decide the case, but they are disputed point on the point of law. They will make request from the constitutional bench. But how to make the request from the constitutional bench? They will pass referred order. Referred order means they will frame the questions, and with that order they will request that we are passing that order, and with that order we are referring the question to the constitutional bench. Please consider it. This is called the referred orders. It means in state of in the Baldev Singh case and Vijay Singh case, in both the cases, Supreme Court Constitutional Bench discussed the question on the basis of referred order. That is, question were decided on the basis of referred question. But in the Arif Khan case, which was landmark judgment in 2018, in this case were decided on the basis of appeal rather than on the basis of referred order. So my point is that in both these two cases, court did not give opinion whether they will be convicted or acquitted regarding the fact of those cases. But in the Arif case, here, due to non-compliance of Section 50, Arif Khan, Urf alias Aga Khan, get benefit of Section 50 and he was acquitted. So my point is that these two cases, that is the Baldev and Vijay Singh, talks about the legal point, that is talks about the ratio, that talks about interpretation of Section 50. And Arif Khan, by quoting the ratio of these two cases, decided whether Arif Khan should be acquitted or convicted. In the Arif Khan case, accused was acquitted. Okay, it means this problem will be solved with these three leading cases and section 50. And one should make a heading conclusion. In the conclusions, clearly write in the semester in one line, in very crystal clear. Don't try to make confuse, otherwise you will get the marks in the same manner. The T will be acquitted, Tripurari will be acquitted. Very crystal clear line is that T will be acquitted. Why acquitted? What is the reason behind acquittal of Tripurari? The reason of this is that non-compliance of Section 50. Why? Because compliance of Section 60 has been declared mandatory in the above mentioned cases. It means Section 50 has been declared mandatory provisions of section 50 must be complied strictly. So non-compliance of section 50, that is the basis for acquittal of the Tripurari. So this is the brief, but in the semester exam, after writing the summary, you have to write summary in this way. After writing the summary, you have to discuss what is the section 50. As you know that I have already discussed the what is the section 50 in the previous classes. Again, I will make in the brief. The point is that section 50, there are two parts of section 40, original as well as inserted clause. Original clause, how to remember the section 50? As you know that once you determine that you have to remember section 50, you can remember. Everything depends upon the willpower. If you have in mind that no, I have to remember section 50, you can remember, but you are not making so much strong willpower. You have to read again, and you can't understand section 50. So my point is that in maximum circumstances, try to remember. Understanding is a good thing, but understanding does not exist for a long time. At one time, understanding as well as remembering the particular sections, you will be you can recollect again whenever you feel necessary. Section 50. I have made the heading. In the heading, I have always told you that whenever you want to read the law, how to read the law. First of all, create imagination. Suppose that in front of me there is a talat, one side, other side is a Shivani, other side is the Suman, other side is the Rima, other side is the Sita. So make some examples, five or six. In this case, Talat is the accused. In this case, Shivani is the police officer. In this case, she was the witness. It means making imaginations, and after making imagination, start reading. You can understand in a very manner. There will be no any problem. For the example, I will make the understanding how to read the section 50. I will take some example. For the example here is that class 1 talks about that. किसी को प्रॉब्लम नहीं हो रही है ना, सब कुछ ठीक चल रहा है ना?
जी सर.
So my point is that suppose that in this way there are the some points. For the example, first person is that duties of authorized officer. For the example, we can take a example of one officer. So we can take this example. For the example, we can say that Bhanu is the authorized officer. For this purpose, class 1, Bhanu is the authorized officer to inform suspected persons. What is the duty of the Bhanu? First and most important duty of the Bhanu, who is the authorized officer under section 42. His duty is that to inform the accused. Who is the accused? Sabaz is the accused. Sabaz is the accused. In that circumstances, Bhanu will inform the Sabaz. What will be informed by the Bhanu? Bhanu will say the Sabaz, I have suspicion. I have doubt that you are carrying the contraband drugs, and I want to make search. And Bhanu will further say that you have two options. Either allow me to make search, first option, or if you say I will not search you, I will produce you before the gazetted officer or magistrate, and in front of that I will make search. So whatever the role is of the Bhanu, that come under the category of class 1. Whatever role is first role is the Bhanu. This is the Bhanu. Come to the second part. Second part, that is the Sabaj. Regarding the option of the Sabaj, after listening statements of the Bhanu, that is the gazetted officer, Sabaj realized what would be better option. Sabaz said that, okay, Bhanu, you can search me, I have no problem. Okay, I am innocent person, I am not carrying anything, you can search. In this way, Bhanu will make search of the Sabaz. But second option is that, second option Sabaz said that, no, At present time, environment is not good, and I have doubt. You are the Brahmins. I am the Muslim, and I have not faith. And I think that you may arrest illegally. You may keep jealous whatever might be that in that matter, and you may indulge me in commission of the crime. शहबाज कहता है कि देखो भानु, तुम ब्राह्मण हो और हमें तुम्हारे ऊपर भरोसा नहीं है क्योंकि तुम्हारे बैच पर ही लिखा हुआ है और इन्वायरमेंट भी थोड़ा ठीक ठाक नहीं चल रहा है और हमें डाउट लग रहा है कि तुम मुझे फंसा सकते हो। तुम ऐसा काम करो, तुम हमारे बॉडी को टच मत करो, हमें गजेटेड ऑफिसर के पास लेकर के चलो। इन दिस केस, दिस इज द सेकेंड पार्ट ऑफ द शहबाज। कम टू द थर्ड पार्ट। Third part, we can take the example of the Parth. Here Parth is the gazetted officers. Okay. Once Bhanu informed, Sabas told him that what is this matter in that way. If such a position is made, that is if Sabas choose second options, then in proceed further. In that circumstances, Bhanu will produce before the gazetted officers. It means he produced before the Parth. What will be duty of the Parth? Parth has two duty. Because Parth has the gazetted officer, Parth has two duty. Parth has two options rather than duty. Parth has two options. First option is that Parth did not get any reasonable grounds for arrest of the Sabaj. Parth will say that, oh Banu, this is bad habit. Without any reasonable grounds, you have arrested the Sabaj. No, release him at once. At that time, Sabaj will be released at once. Okay. Second option is that Parth realized that there are some substance, some doubts. He should make search. In that circumstances, Parth will direct Bhanu. Bhanu makes search Sabaj. In that circumstances, Bhanu will make search of the Sabaj. The class 1, Bhanu, class 2, Sabaj, class 3, Parth. Come to the fourth point. Class 4. Arrest of female by female. Arrest of female by a female. Suppose that Talat has committed a crime. Suppose that Talat has committed a crime. Who can arrest? Whether Bhanu can arrest, who is authorized under class 1 to arrest, or only Shivani can arrest, who is the female police officer, who is authorized under section 42. In that case, in the case of Talat, only and only Shivani can arrest him. That's why section class 4 is just similar to section 100 of the CRPC. If you read the section 100 of the CRPC, which also talks about the search procedure for the search, in that section, it has also been prescribed that female must be searched in presence of the another female. It means female must be searched by another female. So my point is that in this way, class 1, 2, 3, 4 is very clear. Okay, no problem. Come to the class 5. Class 5 also talks about the relaxation in class 1, 2, 3. I write here relaxation in class 1 to 3. I did not mention class 4. Why? Because even under section 100 of CRPC says that women police officer can search another woman. It means woman by the woman. Man is not allowed. Here relaxation in class 1 to 3, search under section 100. Point is that why class 5 and 6 were inserted. You can see that in 2001, both were inserted. What was the reason? Reason was that due to the hardship arised due to the class 1 to 3. Suppose that Sabaj duty, suppose that Bhanu is on duty in the Palgam, remote area of the Palgam, Jammu and Kashmir. He got suspicion on the Sabaj, and Sabaj is well known about the section 50. Sabaj is well known about the section 50 of the NDPS Act. Bhanu asked him, uh, please allow me search. Or you say, if you request, I will produce before the gazetted officer. At once, Sabas choose, okay, Bhanu, don't touch me. You are not authorized to touch me. Produce me before the gazetted officer or before the magistrate. And from that particular place and office of the gazetted officers is near about 100 kilometers away. How much distance between two places? That is the near about 100 kilometers away. What would be happen? In that circumstances, there are two chances. First chance is that it will take, this is the hilly area. It will take near about 5 to 6 hours, 7 hours, 8 hours it may take. What would be happen? In journey, Sawaz may throw out the substance. अब भाई 5-6 घंटे की जर्नी है, आप उसको अरेस्ट कर नहीं रहे हो, आप उसको गाड़ी में बैठा करके लेकर के आना है. अब 100 ग्राम की एलएसडी है, 100 ग्राम की एलएसडी फेंक देगा, पता भी नहीं चलेगा. In the case of LSD, Miss Riya Chakravarti uh, has been arrested. LSD. So my point is that what would be happen? Tomorrow, suppose that after 8 hours, 6 hours, Bhanu produced Sabas before the Parth. What would be happen? Parth will at that time Sabas is without any substance. क्योंकि रास्ते में फेंक दिया हिली एरिया में ही. अब यहाँ पर क्या होगा? भानु को डांट पड़ेगी. Why you arrest innocent persons? In these circumstances, it was creating much more hardship, and it was benefiting to the such accused. So that's why class 5 was enacted. And according to the class 5, it says that in certain circumstances, there is no need to produce before the gazetted officer or magistrate. There is no need to produce before the gazetted officer or magistrate. या फिर गलत कर दिया हूँ, सिर्फ इसमें एक क्लास का होगा. पार्थ, इसको एक कटेगा इसमें से, एक क्लास नहीं रहेगा, सिर्फ 3 रहेगा, सिर्फ क्लास 3 रहेगा. सेक्शन क्लास 3. In that case, what would be happen? That's why class 5 says that there is no need to produce before the gazetted officer, before the magistrate. You have some alternate procedure. What is the alternate procedure? Alternate procedure is that instead of following class 3, you may follow class 5. So what is the difference between class 3 and class 5? Class 3 says that person must be produced before the gazetted officer or magistrate. But class 5 says that in certain circumstances, there is no need to produce before the gazetted officer or magistrate. Merely producing before, merely search before the two witnesses will be sufficient. Section 5 says that presence search before the two witnesses are sufficient, but you have to write the reason, record the reason like this. Recording of reason is class 6. I have already discussed, no need comment. Come to the state of Punjab versus Baldev Singh. Now I will start the case from the here. Because in the initial stage, I told you that at least you have to discuss section 50. I discussed section 50. Another case is that state of Punjab versus Baldev Singh case. Section without state of Punjab versus Baldev Singh is in section 50 without discussion of the Baldev Singh case is immaterial. At the time of writing the semester exam, if once a question is asked, please always write Baldev Singh versus State of Punjab. For 1 minute, you can miss Bijay Singh case, Arif Chandra case. It will be excusable. But non-writing of the State of Punjab versus Baldev Singh will not be excusable. Why I am emphasizing much more? Because NDPS Act was enacted in 1985. 1985. After that, there was a lot of disputes regarding the section 50. First time question was referred to the constitutional bench, and constitutional bench finally laid down the guidelines, 7 guidelines laid down by the Supreme Court in the case of State of Punjab versus Baldev Singh case by the Constitutional Bench and finally settled the dispute. But even after that, question dispute arise regarding the interpretation of the State of Punjab versus Baldev Singh, Joseph case, Prabha Singh, Srimati case. अगर बलदेव सिंह का केस नहीं होता तो तीनों केस आते ही नहीं, चाहे जोसेफ का हो, चाहे प्रभा का हो, चाहे कृष्णा कन्वर का हो, तीनों एग्जिस्टेंस में आते ही नहीं, हम डिस्कस ही यहाँ नहीं करते। क्यों? क्योंकि तीनों ही केस में बलदेव सिंह के रेशियो को लेकर के ही डाउट था, तो बलदेव सिंह केस को डिस्कस करना ही करना है। और इसी रेशियो को क्लियर करने के लिए आपका चौथा केस भी आया, विजय सिंह का केस। इट मीन्स ऑल द 4 केसेस डिपेंड्स अपॉन द रेशियो ऑफ द बलदेव सिंह केसेस। All the 4 cases depends upon the ratio of Baldev Singh cases. Even in the case of Vijay Singh case, Constitutional Bench again said that ratio laid down in the Baldev Singh case regarding Section 50 is perfect and there is no need to modify, there is no need to change. So this is the ratio of the Vijay Singh case. So my point is that Vijay Singh case is the most important. Baldev Singh case is the most important case on this point. Come to the state of Punjab versus Baldev Singh. What was the point? देखो टाइम तो लगता है क्लास डिस्कशन में, लेकिन एक बार जब डिस्कस हो जाएगा ना तो तुम किसी के सामने खड़ा होकर के बता सकते हो कि एनडीपीएस क्या है। ठीक है, थोड़ा सा टाइम लगता है। State of Punjab versus Baldev Singh. In the initial, I told you that even in this case was decided by the Constitutional Bench, and question has been referred to him, that is the doubt regarding the Section 50. And in this case, Supreme Court clarified, Constitutional Bench clarified the doubt of the doubt regarding Section 50, and the ratio was laid down. Come to the ratio. What was the ratio? There are 7 ratio. There are total how many ratio were laid down? So 7 ratio were laid down in this case. But ratio number 4 are not much more important. That's why even in the case of Vijay Singh, only the 6 ratio were discussed. Regarding the ratio number 4, Supreme Court did not discuss and put like in this way. So come to the how to discuss the ratio. Point is that the duty of authorized police officer to inform suspected person. This is the first duty. This is the imperative duty, and it is based on the class 1. It is based on the section 50 class 1. I told you that it is duty of the Bhanu to inform Sabas. It is immaterial whether Bhanu is an advocate, Bhanu is a law professor, each and everything is immaterial. It is your duty to inform. Tomorrow you can't take defense that no, Murari was a law professor in DU. That's why there was no need to inform section 50. There is no violation of section 50. No. In each and every circumstances, you have to inform that it is your right, like this, like this. So that's why first ratio of this case says that section 50 talks about the man imperative for him to inform. It is a duty of the officer to inform. Suppose that, as you know, that once he is informed, he has 2 options. He has 2 options. Accused has 2 options. Regarding the second options, producing before the magistrate. But what happened? Suppose that Bhanu did not inform Sabaj. Bhanu did not inform Sabaj. That is the first time. That is the violation of class 1. Violation of class 1. Again, I will take 1 minute. See your problem. In your problem, what is the basic point? In this case, police make search without saying anything. Without saying anything. This is the important point. That's why what would be effect if police makes search without saying anything? I am going to answer of this question with the help of Baldev Singh case. Come to the point. First, suppose that police officer, that is the Bhanu, did not inform to the Sabas. Second point is that, okay, he informed, And Sabas choose please produce before the magistrate, but Bhanu did not produce before the magistrate. So my point is that either in case of violation of class 1 or in case of violation of class 2 and 3, what would be effect? I will going to discuss the effect with the help of smart art. Come to the point. Effect of search without prior information, that is the violation of class 1, and without producing before the authorized officer, that is the class 2. The here point is that may not vitiate the trial. Supreme Court said that violation of these points will not vitiate the trial. Will not vitiate the trial. But what would be effect of this? There are two parts. First part is that suppose that trial going on. Trial going on, there will be two parts. One part regarding the recovery of illicit articles. Recovery of illicit article. Second part regarding the conviction. So what would be effect on the recovery of goods and what would be effect on the body of the person? So my point is that this talks about the articles that is the whatever recovered goods, and this talks about the manpower that is the man that is the person. So what would be effect? Recovery of articles that is the even contraband goods will come under the category of illicit articles. It means article which was recovered illegally. It means Sabaz will get benefit. Why? Because Bhanu did not inform him. It means recovery. It means seizing the property, contraband goods without information will be illicit article. According to your problem, whatever was recovered, that is whatever opium was recovered, that opium, see, recovered large quantity of opium from the bag. This part, regarding this part, it will be illicit as illegal articles. It means it will be treated that whatever article was received, that was received illegally, and for that accused will not be punished. Okay, this is effect on the recovery of goods. The first point is that on that point, uh, recovery of illicit articles. This is the points. Okay, regarding the problem, whatever opium was recovered from the possession of the from the bag of the Tripurari will be treated as a recovery of illicit articles, and for that there will be no punishment for the Tripurari. Regarding the conviction, what would be regarding the conviction? Whether Tripurari, that is the T, will be convicted or will be acquitted in case of violation of Section 50 of the NDPS Act. This will be divided into two parts. Suppose that Tripurari was convicted. Tripurari was convicted solely on the basis of recovery of the contraband goods. In that case, conviction will vitiate. It means in that case, Tripurari will not be convicted. Why? Because you are convicting the Tripurari on the basis of recovery of the articles, and that recovery of articles itself has become the illicit. How can you convict a person on the basis of illicit articles? बात समझ में आ रही है कि नहीं तुम लोगों को?
जी सर, आ रही है।
हाँ, प्रॉब्लम यही है कि अगर आपके पास ओपीएम की रिकवरी हुई और वही ओपीएम को इलीगल कर दिया गया, कहा गया कि भाई ओपीएम क्या था, कैसे था, प्रोसीजर फॉलो ही नहीं किया गया, इसलिए हम उसको इलीगल मान नहीं रहे हैं। तो जब ओपीएम की रिकवरी को इलीगल कर दिया जा रहा है, इसका मतलब उसके पोजीशन को वैलिड मान लिया जा रहा है, तो उसी वैलिड पोजीशन के बेसिस पे आप कैसे किसी का कन्विक्शन कर देंगे? वर्ड इसमें सोलली सिर्फ उसके आधार पे किसी व्यक्ति का कन्विक्शन नहीं करेंगे। यहाँ पर सिर्फ वन है, यहाँ पे 1+1 2 नहीं है, यहाँ पे क्या है, सिर्फ वन है, और वन भी क्या हो जा रहा है, एक मिनट, सिर्फ क्या है यहाँ पे 1 है, और वो भी 1 क्या है, एक्यूज के फेवर में वैलिड मान लिया जाता है, और भानु के फेवर में, पुलिस के फेवर में इलिसिट मान लिया जाता है। इसके बेसिस पर कन्विक्शन नहीं होगा। लेकिन फॉर एग्जांपल सेकेंड पॉइंट, इफ there are two evidence, there are group of two evidence. First group of evidence is that recovery of illicit articles, and second group of evidence is that, for the example, section 30 of the co-accused, confession made by the co-accused, or on the basis of section 27, or of the Indian Evidence Act, section 30 Indian Evidence Act, or section 133 accomplice. That's my point. So my point is that if there are two parts of evidence, one is that regarding the illicit articles, and another is regarding the independent evidence. For example, section 30, section 27, 133. In such circumstances, he will be convicted. Why? Because he is not being convicted on the basis of illicit articles. He is convicted on the basis of the accomplice, on the basis of co-accused, on the basis of recovery नहीं, discovery of क्या एक वर्ड होता है, discovery of facts, on the basis of discovery of facts. इस तरह रिकवरी एक डिस्कवरी है, जो भी होगा थोड़ा सा डिस्कवरी लग रहा है मुझे। माय पॉइंट इज दैट, तो हमारे कहने का मतलब है यहाँ पे एविडेंस के दो पार्ट हुए। पहला पॉइंट है कि इलिसिट आर्टिकल है, और उसके साथ साथ में प्लस में ए भी आ जा रहा है। इसके प्लस में होने की वजह से इसके बेसिस पर इसका कन्विक्शन हो रहा है। तो हमारे कहने का मतलब है कि वेयर देयर विल बी ओनली एंड ओनली evidence regarding recovery of the goods, on that basis conviction will vitiate. It means he can't be convicted, he will be acquitted. But there are some illicit articles as well as some other independent evidence for these examples, then he will be convicted. So my point is that in the Tripurari case, you have to argue, you have to argue, you have to say, because here argument is silent on this problem. See, problem is very simple. He recovered large quantity of bags. He was arrested. He defends non-compliance of Section 50 of the NDPS Act. So you can argue. You can say that, okay, Millards. For example, Kusum is fighting on behalf of the state. Kusum said that, okay, Millards, there was illicit articles due to non-compliance of Section 50, but there are some independent evidence. For example, some accomplice, some co-accused like this, he must be convicted. It depends upon the argument. You have to argue on both sides. You have to make argument, Millards. If there is a alone articles, in this case, there is alone evidence based on the illicit, conviction of Tripurari is wide, not valid. But if there are some dependent evidence regarding which problem is silent, regarding the evidence, problem is totally silent. In this way, you can make argument. Come to the point ratio number 5, 6, and 7. I have again clubbed ratio number 5, 6, and 7 with the self. Question is that whether compliance of section 50 is mandatory. In this case, Supreme Court clearly says that I am not giving opinion whether section 50 is mandatory or directory. But in Vijay Singh case, the court clearly said that section 50 is mandatory. In this case, court clearly said, okay, I am not going to give the opinion regarding whether mandatory or directory. But compliance of section 50, strictly compliance of section 50 is imperative. एक वर्डिंग का गेम है, देखो हम, क्योंकि सुप्रीम कोर्ट भी बहुत बड़ा गेम खेल जाता है ना। देखो सुप्रीम कोर्ट ने क्या कहा, कहा इसमें, we do not express any opinion whether provision of section 50 are mandatory or directory, okay, but we hold that failure to inform the person accused to write managingly may render the recovery of the contraband suspect and conviction and sentence on accused bad and unsustainable in law. Suppose that one side I am not saying that whether path is good or bad, but other side I am saying that I am not saying that Parth go and perform this act. I am not saying it is whether mandatory or directory. But other side, I said that once you did not perform this act, I will fail you in exam. So what is the meaning of? अगर हम कहें कि देखो पास एक क्वेश्चन है, अब हम ये नहीं कहेंगे कि लिखना डायरेक्टरी है कि मैंडेटरी है। अब तुम अपने हिसाब से इंटरप्रिटेशन करो कि डायरेक्टरी है कि मैंडेटरी है। हाँ, बस मैं इतना जरूर कर दे रहा हूं कि अगर इसका आंसर नहीं लिखे तो इससे तुम्हारा मार्क्स कट जाएगा। इस पॉइंट से एक मिनट। हाँ सर, मैं कॉल करता हूँ, ऑनलाइन क्लास ले रहा हूँ। अच्छा अच्छा, ठीक सर, ठीक सर। ओके, थैंक यू सर। So my point is that here, so one side I am saying that you, it is not, I am not saying whether directory or mandatory, but the other side I am saying that if you will not write the answer, I will cut marks. So what is the meaning of this? इसका तो मीनिंग यही निकल करके आता है ना कि दिस इज द मैंडेटरी। सी द वर्डिंग, वी डू नॉट, दिस इज द वर्डिंग ऑफ द सुप्रीम कोर्ट, वी डू नॉट एक्सप्रेस एनी ओपिनियन whether provision of section 50 are mandatory or directory, but hold that failure to inform the person concerned of his right as enumerating clause 1 of section 50 may render the recovery of the contraband suspect regarding the goods, may render the recovery of contraband suspect, and conviction and sentence are accused had are bad and unsustainable in law. So my point is that indirectly it is saying that section 50 is mandatory. इस point को later on will be clarified. Now, in this case, Section 50, we can clearly say that although Supreme Court did not express their opinion, but Supreme Court said that in case of violation of Section 50, what would be effect? In case of violation of Section 50, these ratio are just similar to ratio of class 2 and 3. जो यहाँ पर मैं डिस्कस किया था ना, this will keep if the in case of non-compliance, recovery of goods will be illicit, conviction will be seat. It is just similar to that ratio. Here, effect of violation of section 50 is talks about the. You can ask what is the basic difference between those ratio and here. Why Supreme Court has repeated again and again? No, Supreme Court did not repeat again and again because this part talks about the class 1 and class 2. This is basically based on the prior information class 1 and producing before the authorized officer. This talks about the class 1 and class 2. But this ratio talks about the whole section of the section 50. It talks about whole section of section 50. It says that recovery of the contraband suspect in case of violation of section 50, whatever contraband drugs will be recovered, that will become under the category of contraband suspect. And here, in case of conviction, conviction and sentence of an accused will be bad and unsustainable in law. And only on that basis, only on the recovery of illicit articles, you cannot initiate another offense under the IPC. For example, unlawful possession. एक है ना वहाँ पे सेक्शन है 411, 12, 13, 14 का है कि stolen property, conviction for the recovery, conviction for the unlawful possession like this, like that. It means it was said that for on the basis of the contraband suspect, if recovery is illicit, you can't convict him. So my point is that these are the 7 ratios which you have to discuss and remember. In brief, you can clearly how to remember. In brief, in layman, you can clearly say that in this case, although court was silent, whether the section 50 is directory or mandatory, but interpretation of the words clearly show that it is a mandatory. That's why it was confusion arised in the case of Joseph case, Prabha case, and Mr. Krishna case. Why? Because यहाँ पे कोर्ट ने यही कहा कि हम एक्सप्रेस नहीं करते कि डायरेक्टरी और इनडायरेक्टरी। इसी पर एक कंफ्यूजन हो गया कि whether section 50 is mandatory or directory. According to one court, according to the 2 cases, it was said that Joseph and Prabha, it was said that no, it is not mandatory because Supreme Court did not say whether it is directory or mandatory. Substantial compliance is sufficient. But on the another side, Mrs. Krishnan, court said that no, don't read only this line. Don't read only this line. Please read whole the line. If you read the whole line, it becomes very clear that section 50 is mandatory and substantial compliance is not sufficient. मैं समझ में आ रहा है कि ना? इन दो केसों में जोसेफ का केस था और प्रभा को उसमें कहा गया था कि सुप्रीम कोर्ट ने इसको डायरेक्टली नहीं मैंडेटरी नहीं कहा है, इसका मतलब सब्सटेंशियल कंप्लायंस सफिशिएंट है। ये दो ओपिनियन था, ये ओपिनियन जोसेफ का था और प्रभा का। लेकिन जो दूसरे साइड का ओपिनियन था जिसमें एक उसका कहना था, मिस कृष्णा का कहना था कि नो, सब्सटेंशियल compliance is not sufficient. You should read whole the provision, whole the ratio, and once you read the whole ratio, you can understand that section 50 is mandatory. And this problem was clarified in the case of Vijay Singh, whether this is mandatory or substantial compliance is sufficient. In Vijay Singh case, court clearly said that this part must be read whole and substantial compliance is not sufficient. Section 50 is mandatory. In the next class, I will discuss the see here why the confusion was arise. On one side, regarding the interpretation of Vijay Singh case. On the one side, Joseph case and Prabha was saying that court was silent whether it is mandatory or directory. It means substantial compliance is sufficient. On the another side, state of Punjab said that no, you should have to read whole ratio, and after reading the whole ratio, it becomes that section 50 is mandatory. पार्थ इसको नोट डाउन कर लेना, यहाँ पे मैंडेटरी का लिख दूंगा कि इट इज ए मैंडेटरी. Now in the next class, I will discuss the Vijay Singh Chandba Jadeja versus state of Gujarat. अब हमें लग रहा है कि फॉर द टुडे क्लास दैट इज सफिशिएंट. नेक्स्ट क्लास में डिस्कस करेंगे हम लोग, है ना? इतना काफी है.
जी सर.